Hello, and welcome to Federal Appraisal LLC's video series. In this video, we will discuss the various property interests, estates, and rights an appraiser can appraise. An appraisal provides an opinion of value for a given interest in an asset or a property. Different interests often have very different values. Sometimes these interests are referred to as estates. Therefore, an appraiser must clearly and completely report what interest, estate, or rights have been appraised. Most frequently, real estate appraisals give values in terms of fee simple interests, or leased fee interests, or leasehold interests, and business appraisals give either undivided or partial interests. However, there are a large number of interests that could be appraised. Here is a list of some. Unencumbered fee simple ownership means that you own the full bundle of rights to that property. You can occupy and use the property as you wish. You can rent out a portion of it, rent the entire property, or you can sell or subdivide the property. You can also build new improvements, modify the existing improvements, or even demolish everything at your will. The property is yours, and you can do with it what you wish, subject to the four inherent rights of government, which include escheat, police power, taxation, and eminent domain. Unencumbered fee simple ownership is as pure as it gets, but it is not unlimited. The government at all levels has rights over even unencumbered fee simple estates, and they regularly exercise this authority. So unencumbered fee simple ownership means only that no part of the bundle of rights inherent in the unencumbered fee simple ownership has yet been divided off or separated, sold, or given or otherwise transferred to another party. The paradigm for rights and interests in property is called the bundle of rights and is known as the bundle of rights theory. We prefer to think of this bundle as a bucket. Imagine that a bucket is filled with the rights inherent in a fee simple estate and is filled to the rim. Other estates and interests can be thought of as a bucket that is less than full because some of the bundle of rights have been scooped out and transferred to others. The more rights that have been transferred to others, the lower the level in the bucket. The level of the bucket can be thought of as the value of the remaining bundle of rights. If all the rights have been transferred, the value remaining is zero. If all the rights inherent in the fee simple estate are present in the bucket, the value of the bucket equals the full fee simple value. If only a minor right is transferred, say a de minimis easement at an innocuous location on the property, then the value remaining in the bucket is at or near the full fee simple value. If a major easement or some other major bundle of rights are taken or willingly transferred, then the value remaining in the bucket is substantially less than the fee simple value. Any lease on the property separates this bundle of rights. If you, as the property owner, choose to lease out a property, you are now a lessor, more commonly known as a landlord, and have the least fee interest in the property. Your bucket, once full with all the property rights, is now partially emptied because the right to occupy and use the property has now been transferred to your lessee. The lessee, more commonly known as a tenant, has the leasehold interest in the property. Typically, a property owner grants a tenant the right to occupy their property for monetary compensation, called rent, which under market terms represents your compensation to forego your rights transferred. The rights of the leasehold interest, such as what portion of the property the tenant can occupy, how long they can occupy it, and the manner in which they are allowed or barred from modifying the property, and numerous other specifications and rights are all spelled out in the lease. Thus, leases are complex. For that matter, properly understanding many partial interests and estates may require legal counsel, as these interests are often established by contracts and covenants. In fact, these rights may require legal, accounting, and engineering opinions to parse out. Water rights in California are one such example. Another example includes easements or rights-of-ways taken through condemnation for utilities and roadways on estates that already have old easements, rights-of-ways, deed restrictions, or other rights taken. In business appraisal, the issue of undivided and partial interest is common. Analogous to fee simple estates in real property, an undivided interest in a business or business asset is like a bucket filled to the rim. One of the main concerns in business appraisal with divided interests is whether the remaining interests are controlling or non-controlling. A controlling interest means the remaining interest has the ability to control the business activities and decisions, and can control what the business does and does not do. This is more valuable than a non-controlling interest, where the owner does not have the control of the business activities and decisions. Non-controlling interests are therefore discounted from their pro rata share for this lack of control. For example, even if two parties each had 50% in a business, but only one had control, the value of each party's bucket would not be 50-50. The controlling interest may have a value of 60% of the overall business value, while the non-controlling interest may have a value of only 40% of that overall business value. Thus, the original bucket of value is not divided evenly. This last example brings up an interesting condition. In this example, it is found that the sum of the two divided interests tally to 100% of the value of the undivided interest. In the real world, this is not always the case. Sometimes dividing a fee simple estate or a full business interest results in pieces that do not tally to the value as if there were no division. Generally, real estate appraisal theory holds that the value of the leased fee interest plus the value of the leasehold interest equals the value of the fee simple interest. In various circumstances, such as a lease that prohibits the highest and best use of the property, this equation will not be valid. Now the sum of the values of the two buckets of rights for the leased fee and the leasehold will not tally to the unencumbered fee simple value. Now the equation includes the value destroyed by the restriction in order to equal the value of the fee simple interest. If you've made it to this point in the video, you will have a solid understanding of the different types of property rights. But given the unique circumstances of each property and business, the impact of any given division of interests or bundle of rights cannot be generalized. Each circumstance requires its own examination and analysis, and requires expertise to discern the meaning and value. Make sure to subscribe to our channel for more exclusive appraisal content from the pros at Federal Appraisal, and we'll see you in the next video.